What's good, everybody? How y'all doing? Are y'all doing all right? I hope you are. Well, I guess I should have asked, are y'all doing poorly? I hope you're not. I hope you're not doing poorly tonight. Let's get into it. We are finishing up YouTube's terms of service. This is part 2. We finished after completing your content and conduct. Once again, I am not giving legal advice. This is just me reading through the terms of service myself and speaking out loud my own thoughts on it. But yes, do consult with a bar licensed lawyer if you are looking for legal counsel or legal advice on any of these terms or anything that you've heard here. But I did graduate law school, Pepperdine Law, class of 2022. So, not for nothing. Here we go. Community guidelines, strikes. Forget my voice today. YouTube operates a system of strikes in respect of content that violates the YouTube community guidelines. Each strike comes with varying restrictions and may result in the permanent removal of your channel from YouTube. A full description of how a strike affects your channel is available on the Community Guidelines Strikes Basics page. If you believe that a strike has been issued in error, you may appeal here. If your channel has been restricted due to a strike, you must not use another channel to circumvent these restrictions. Violation of this prohibition is a material breach of this agreement, and Google reserves the right to terminate your Google account or your access to all or part of the service. Now, that is interesting. This is the first time I recall, even from the other video, seeing a violation on YouTube that can affect a Google account. I mean, I know that YouTube technically is a Google account because YouTube is owned by Google, but this is the first time I believe that it's mentioned it this way. So I'm talking about this here still. The violation of this prohibition is a material breach of this agreement, and Google reserves the right to terminate your Google account. But anywho, it just sounds like I take strikes kind of like in soccer or football, European football, that is. They have yellow cards, right? You get one yellow card. If you get two yellow cards, that turns into a red card. And it's kind of the same here with strikes, it sounds like. With each strike, there's just, similar, but rather than just no restrictions, rather than just a warning, each strike comes with its own varying restrictions. But yes, if you get too many, and I think soccer is also apt for that because it gives you a proper sense of how many is likely too many. There's maybe a shot that it's 3 strikes, but it's safe to assume 2 strikes is enough to remove you to permanent removal. But also that 1 strike can, because you can always get a straight red, you know? So, that's not there. Copyright protection. We provide information to help copyright holders manage their intellectual property online in our YouTube Copyright Center. If you believe your copyright has been infringed on the service, please send us a notice. We respond to notices of alleged copyright infringement according to the process in our YouTube Copyright Center, where you can also find information about how to resolve a copyright strike. YouTube's policies provide for the termination in appropriate circumstances of repeat infringers' access to the service. Okay. So, along with the strikes, of the strikes that can happen, there's also copyright strikes can happen. I guess a channel can be restricted due to a strike for infringing on someone else's copyright, which is to say, using someone else's copyright without their permission. It sounds fair enough. Again, none of this is legal advice, but this is just me talking out loud. This is what it sounds like. Account suspension and termination. Terminations by you. You may stop using the service at any time. Follow these instructions to delete the service from your Google account, which involves closing your YouTube channel and removing your data. You also have the option to download a copy of your data first. Terminations and suspensions by YouTube. YouTube reserves the right to suspend or terminate your Google account or your access to all or part of the service if A, you materially or repeatedly breach this agreement, B, we are required to do so or to comply with a legal requirement or a court order, or C, we reasonably believe that there has been conduct that creates or could create liability or harm to any user or third party, YouTube, or our affiliates. YouTube and friends. Right. So, along with you being able to delete your own account or suspend it, YouTube can do that if you breach this agreement or through some legal procedure they have to, or if they quote unquote reasonably believe that there has been conduct that creates or could create like a legal harm to any of their homies, any of their friends. Checks out. Seems like pretty standard. Notice for termination or suspension. Forgive me, notice for termination or suspension. We will notify you with the reason for termination or suspension by YouTube unless we reasonably believe that to do so, A, would violate the law or the direction of a legal enforcement authority, B, would compromise an investigation, C, would compromise the integrity, operation, or security of the service, or D, would cause harm to any user or third party, YouTube, or our affiliates. Once again, that sounds pretty standard. Like they'll let you know why they terminated you or they suspended you, unless it's going to break the law or hurt a lawful investigation, so they say. Or if it would like compromise YouTube somehow, or YouTube's friends. So, always protect YouTube and friends. Effect of account suspension or termination. If your Google account is terminated or your access to the service is restricted, you may continue using certain aspects of the service, such as viewing only without an account. And this agreement will continue to apply to such use. If you believe that the termination or suspension has been made in error, you can appeal using this form. So even if your Google account is terminated, like you will at least still have limited access to YouTube. for viewing purposes only. You just don't get the benefits of having an account. So you can't do things like liking pages, commenting, subscribing, etc. And it still doesn't mean that like you just can't, like you're still bound to the agreement with YouTube even if you don't use your account. It just means that there's less. It feels like things you have to worry about that could go wrong because you just have less. You're already more restricted in your access. You know, like if you what am I trying to say? It sounds like it looks like it feels like. Yeah, well, because if your account is already terminated or suspended, then you already have being able to view only videos means that there's only so much that you could do that could like hurt, or break the terms again. You've already done it to the point where you're terminated, and you're terminated or suspended, or if you're suspended especially, you're likely suspended from, well, the account activity that you were allowed to do. So you're not suspended from viewing, but I'm sure, I don't know, maybe there's some way that you could use a bot or something and go into YouTube and hurt their systems. I don't know. But the point is the same, nonetheless. You got the idea. About software and the service. Downloadable software. When the service requires or includes downloadable software, such as the YouTube Studio application, unless that software is governed by additional terms which provide a license, YouTube gives you a personal, worldwide, royalty-free, non-assignable, and non-exclusive license to use the software provided to you by YouTube as part of the service. This license is for the sole purpose of enabling you to use and enjoy the benefit of the service as provided by YouTube in the manner permitted by this agreement. You are not allowed to copy, modify, distribute, sell, or lease any part of the software, or to reverse engineer or attempt to extract the source code of that software unless laws prohibit these restrictions or you have YouTube's written permission. I wonder what laws do prohibit those restrictions. I kind of want to ask ChatGPT. I won't hold you, Chat. So we're definitely going to copy that. But this is an interesting one about software and the service. So, like YouTube Studio application. I don't know what YouTube Studio application is, chat. Does anyone else familiar with YouTube Studio application? I'm not going to look it up now, but that's another term I need to look up. Unless that software is governed by additional terms which provide a license. Because this is the first time that I've seen, well, this is the first that I'm reading. So they give us basically a relatively free license to use the software provided by YouTube as part of the YouTube service, basically. So any add-ons, any downloadable content or downloadable software, I need to be correct, any downloadable software that YouTube provides is, unless governed by additional terms, etc., we're able to use it, but solely for the purpose, enjoyment, and benefit of YouTube's service, and we can't break it down to find out what its source code is and use it for our own purposes. Which is, but I guess that's just standard with technology. Um, it's not like a car where you own the car and now you can just take the car apart if you feel like it, put it back together with a souped up engine and different tires, different everything. But that's what it means when you're granted a license. A license is like a right to make use of without necessarily owning it, which means if they say, like, you can use this, but you can't modify it, you can't modify it. And that's the point. You can't modify it, copy it, distribute it, etc. Like, this is a one-off thing. We're being very generous in allowing you to use it. Don't make light of that. Open source. Some software used in our service may be offered under an open source license that we make available to you. There may be provisions in an open source license that expressly override some of these terms, so please be sure to read those licenses. Huh. Those licenses. So now I need to check the open source licenses. So it seems. Copy. I don't know where I'm going to find those. Since they usually give these like hyperlinks, if you notice. See the blue? This blue here. Or this blue here, instructions, copyright center. But I'm not seeing any, I haven't seen any for open source licenses. And you would think it would be right in this section where it says open source, but that's not. Well, I'll just have to continue. Other legal terms. Warranty disclaimer. Other than as expressly stated in this agreement or as required by law, the service is provided as is, and YouTube does not make any specific commitments or warranties about the service. For example, we don't make any warranties about A, the content provided through the service, B, the specific features of the service or its accuracy, reliability, availability, or ability to meet your needs, or C, that any content you submit will be accessible on the service. Yeah, that's extremely normal sounding. Sounds pretty normal. When a service or a thing is provided as is, it's kind of like those souvenir stores, or even resale clothing stores. There's a name for this that's just flying over my head. Discount clothing stores, what have you. The shirts are usually, they sell as is. You know, they might not be in the perfect condition. You might be like, oh, this shirt is fading some. No one cares. It's provided as is. You buy it as is. They're like, we're providing a service. Like, this is it. Like, we're doing our best, but don't come at us legally for being disappointed in what we provided. Limitation of liability, except as required by applicable law. YouTube, its affiliates, officers, directors, employees, and agents will not be responsible for any loss of profits, revenues, business opportunities, goodwill, or anticipated savings, loss or corruption of data, indirect or consequential loss, punitive damages caused by errors mistakes or inaccuracies on the service, personal injury or property damage resulting from your use of the service, any unauthorized access to or use of the service, any interruption or cessation of the service, which is like cessation or like any interruption or like halting, a stop on the service, any viruses or malicious code transmitted to or through the service by any third party, any content, whether submitted by a user or YouTube, including your use of content and or the removal or unavailability of any content. This provision applies to any claim, regardless of whether the claim asserted is based on warranty, contract, tort, or any other legal theory. YouTube and its affiliates' total liability for any claims arising from or relating to the service is limited to the greater of A, the amount of revenue that YouTube has paid to you from your use of the service in the 12 months before the date of your notice in writing to YouTube of the claim, and B, $500, whichever is greater. Months before the date of your notice. I mean, this is stated liability limitation. I'm just reading through. I was reading through this section here again, but this is. I don't know how to explain this better for someone else, but in general, this is just something that every company kind of does. You know, it's like kind of protecting your ass as much as possible. But you'll notice other things, like it says except as required by applicable law. Because as much as every company would like to just say, you know, like we're not liable for anything, right? Like, you know, damn near everything on the service. I mean, they're saying errors, you know, errors, mistakes. Obviously, personal injuries not going to apply so much here with YouTube. I doubt. I mean, maybe the odd parent trying to sue YouTube for personal injury to their son's eyes or their child's eyes because they have spent so much time sitting in front of YouTube, or maybe their back because they spent so much time sitting watching YouTube videos instead of playing or something stupid like that. But that's just not really legally suable for. But again, yeah, it's even though that they say all these things, there are laws like that the company can't get out of, that they must perform. You know, like they do still have some duty to like provide us like the service to some degree. Like there's still some expectation, perhaps, on the part of like the consumers, the users, the buyers. Well, I suppose that's a little less, well, a little trickier here because it's not so much a buyer-seller thing, but it's still a contractual agreement. So, but anywho, it basically it doesn't protect them from everything, which is why it still starts off with except as required by applicable law at the top, and why it then finishes with what the damages would be from any claims that arise, as they would lay it out, because they, in laying out the contract, usually are the ones able to perhaps decide that. I don't know. I I need a lot more context on this entire section right here myself. So more questions there, but we love new questions, baby. That's how we know we learning. Indemnity. To the extent permitted by applicable law, you agree to defend, indemnify, and hold harmless YouTube, its affiliates, officers, directors, employees, and agents from and against any and all claims, damages, obligations, losses, liabilities, costs, or debt and expenses, including but not limited to attorney's fees arising from your use and access to the service, your violation of any term of this service, your violation of any third-party right, including without limitation any copyright, property, or privacy right, or any claim that your content caused damage to a third party. This defense and indemnification obligation will survive this agreement and your use of the service. Yeah, so uh, the indemnity sounds like it's just saying, like, if you cause our service like, any costs, any expenses, any damages, right? If you damage our service and then that costs us a pretty penny, or even just like a noticeable penny, then then uh, like you agree to basically recognize that absolutely none of it is our fault. You come to our defense. You say like it's like it's on you. And not only is it on you, but you agree to legally say that, nope, this is on me. This kind of helps to like wrap up some of these legal cases, these legal situations quicker, because then it saves the time for having to go through court and all that. It can, perhaps. Third-party links. The service may contain links to third-party websites and online services that are not owned or controlled by YouTube. YouTube has no control over and assumes no responsibility for such websites and online services. Be aware when you leave this service, we suggest you read the terms and privacy policy of each third-party website and online service that you visit. Again, this is what I am seeking to do for the people, because I don't think anyone has the time or the energy to read each and every terms and privacy policy of each third-party website and online service that they visit. Like, I alone have a bunch of tabs open right now, and many of them are or almost all of them I think I have are for terms and conditions, and yet it's taken me just 2 hours, well, at least an hour and a half so far, but going on 2 hours to try to get through all these, and I haven't even begun to really push through YouTube's. Haven't gone through the community guidelines, this policies, this privacy policy, data processing terms, which is its own thing. Anyway, but nice reminder, I suppose, that that is something that we might consider doing or want to be aware of. Because yes, you can there are links from this service to other services. YouTube's not responsible for what those other services do. YouTube is like a wooden post outside, one of those telephone posts where you can post things on. You can post stuff on it, but it's not responsible for the stuff that's actually on it. It's just a wooden beam. About this agreement. Changing this agreement. We may change this agreement, for example, 1, to reflect changes to our service or how we do business. For example, when we add new products or features or remove old ones. 2, for legal, regulatory, or security reasons. Or 3, to prevent abuse or harm. If we materially change this agreement, we'll provide you with reasonable advance notice and the opportunity to review the changes, except 1, when we launch a new product or feature, or 2, in urgent situations such as preventing ongoing abuse or responding to legal requirements. If you don't agree to the new terms, you should remove any content you uploaded and stop using the service. Okay, let's break this down. So there are more than just these 3 reasons why YouTube might change the agreement or update the agreement. It can just be changing how they do business when they add new features or remove ones. It can be for a legal change that they have to go through, perhaps like a new law is going into effect and they need to change their compliance. And so something has to change in the terms. So there's all sorts of reasons why they might change it, but they will give you notice unless, again, like, and so they'll give the opportunity to review changes as well, except when they launch a new product or feature, because they want it to be new and fresh. I imagine is the thinking there. Sounds right to me. It sounds reasonable to me. And number 2 is in urgent situations such as preventing ongoing abuse. So yeah, like if they'll give us notice unless they mean not to give notice because they would ruin the surprise. If you don't agree, stop using it. Once again, continuation of this agreement. If your use of the service ends, the following terms of this agreement will continue to apply to you. Other legal terms about this agreement and the licenses granted by you will continue as described under duration of license. Let's say this entire part, because that is these are very important sections right here is what this is telling me. Other legal terms about this agreement and duration of license. Other legal terms. Okay, so see paid service terms, copyright notices, collecting society notices, paid service. Okay, so I'm coming back to here, but I'm looking for other legal terms and about this agreement. And because I'm in about this agreement. So the rest of this will continue to apply. Where's the other legal terms? Is that right here? Other legal terms. So the other legal terms were the warranty, the limitation of liability, the indemnity for it being our fault, and the third-party links are not their fault either. So like, don't add us if you're disappointed for the service. You take it as you see it. And if you do something, then you outright say that it's not our fault. And if you see some third-party stuff, that's their business, what the third parties do. And of course, the durations of license. This is the last thing that would continue. Another durations of license. The licenses, I'll read this again. The licenses granted by you continue for a commercially reasonable period of time. A commercially reasonable period of time after you remove or delete your content from the service. That sounds... What the hell is commercially reasonable is the real question. Commercially reasonable. You understand and agree, however, that YouTube may retain but not display, distribute, or perform server copies of your videos that have been removed or deleted. To which I ask, what are server copies? So first, copy is commercially reasonable. What are server copies? Nevertheless, but that was the continuation of this agreement. Moving on to severance. If it turns out that a particular term of this agreement is not enforceable for any reason, this will not affect any other terms. Yes, so again, like, they put out the terms here, but that doesn't mean that all of these are enforceable. Just because they don't want to be liable for a lot of stuff doesn't mean that they automatically are just because they put it down in writing. This just helps guide that writing process a lot and makes it simpler for the courts than to force them to like decide every little thing on their own. The courts can look at this paper and say, okay, as long as all of this is legal and, you know, doesn't clash with any of our laws, oh, maybe this kind of clashes, etc. So, right. Even if one term is bad on this, however, like that doesn't mean that this entire contract is like null and void. For that to happen, you need something like something called unconscionability. Unconscionability is when a contract is so wildly like disproportional or just asymmetric. You know, one side is getting pennies and the other side is getting gold by the bushels. And it's like, well, they agreed to it, but no reasonable human being would like allow this to happen. An unconscionable contract now would be like some of the contracts back in the day for like Native American land. How much money was given up for that land? A law judge would likely call that unconscionable because you can't say that they can respect or recognize what they're giving up for you know, what they sold it for, etc. That's just one example, but again, None of this is legal advice, just me talking out loud. On to no waiver. If you fail to comply with this agreement and we do not take immediate action, this does not mean that we are giving up any rights that we may have, such as the right to take action in the future. That's important to include, actually, just because there are situations where if someone's doing wrong on, like, in your platform or your business or your even in your property, but you ignore it for like long enough and they just continue, then it can sort of come to be seen as like a custom in a way, and that is like normal behavior, and then it becomes okayed. In the property world, it's happens if a squatter squats on your property unbeknownst to you for a long enough period of time. I want to say it's something, or it used to be something like 10 years, without you like kicking them out formally, or at least like welcoming them onto your property formally in some way, shape, or form. Then the squatter can basically claim squatting rights and live there. Like you can't remove them from that property anymore because they've established it as like their sort of custom, like normal home. They have a custom of going back there, even if they don't own it. So that's why they're including this no waiver, is my best guess. That sounds right to me, and rightfully so. Interpretation in these terms, including or including means including but not limited to, and any examples we give are for illustrative purposes. I noted this already when it was last mentioned. Let me see where else including. Where is it here? Okay, such monetization may include displaying ads or within on or within content, or charging users a fee for access. But in other words, YouTube has other ways of monetizing this content that they're just not telling about, which is fun. I wonder if we have a right to know the other ways in which they use to monetize the content, but I guess maybe not fully, because that's some of their business. I'm not gonna think too hard about that one, but I think I answered my question. Just going back, sorry for that. But that's included. Governing law. All claims arising out of or relating to these terms of the service will be governed by California law, except California's conflict of laws, and will be litigated exclusively in the federal courts or state courts of Santa Clara County, California, USA. You and YouTube consent to personal jurisdiction in these courts. That's a slightly interesting one. So there's personal jurisdiction, and then there's Jesus Christ. I keep saying federal jurisdiction. Is that even right? Personal jurisdiction. That there's personal or federal jurisdiction is what's required in order to to have a case held in a federal court, at least. Like you have to have minimum contacts or something else within the state. I'm not gonna get into all that. But bottom line is, I guess that they just want these cases to be done in California. So I guess they seem to think that California's courts are more favorable to them. I know that you might have recognized from the first video that they are incorporated in Delaware, but that, yes, under the laws of Delaware. And so then you're wondering, well, how can that be that they're incorporated in the laws of Delaware, but then down here they're saying if a lawsuit has to come up, though, then the laws of California rule. Right? Because when it says the service will be governed by California law, that's saying, like, if this goes to court, we won't look at Delaware law and use that to decide who's right and who's wrong. We will look at California law. So, the reason for that, the reason for it is just you're just kind of allowed to an extent, because you can't just choose and pick and you couldn't just choose, for example, like a court in I don't know, Rhode Island or Alaska, just because there are courts in Alaska and there are courts in Rhode Island, and you want to. Like, one of you has to have some sort of contact connection to that state. So even though the YouTube's services is incorporated in Delaware, that doesn't mean that maybe their headquarters are there. Incorporated is really just like a legal thing. It's like where their legal paperwork, you could almost call it, is sent to. You could think of it like that. It's just like where it's legally recorded, but that's really it. It's legally recorded in Delaware. And there's certain things from that law, like from Delaware law, that will apply, but it's like there has to be business, like some business buildings, or you have to be doing business. You have to have stores in the place where you're going to use for your governing law. But to the extent that, like, if you have, say, the most, like, a bunch of stores in California and a bunch of stores in Nevada, then you could likely choose either one to be the governing law that you want to be bound by. But that's what's required, bottom line. So all this is standard enough, and this sounds fine. Limitation on legal action. It's also fine for me because I live in California. Go California. Woo woo. Los Angeles. SoCal. All right. Limitation on legal action. And this will be the closer. Ring ring. Ding a ding ding. You and YouTube agree that any cause of action arising out of or related to the services must commence within 1 year after the cause of action accrues. Otherwise, such cause of action is permanently barred. All right, that's an interesting one too. Is that says if you have a problem with YouTube and you want to bring up some legal, you want to take it to court or you want to take it to a lawyer, then you have 1 year within which to get started or to get that the oh my goodness, Chat, it's right. It's floating around my head, chat. The complaint. A case begins, a legal case begins with a complaint. A complaint is a document that a lawyer has to submit to a court that starts the whole action off. Once the court gets it, they verify it was properly submitted, which means that all of the writing was correctly formatted and all this other crazy technical stuff that's so super annoying to most lawyers, but that's the price that they pay to get the money. Yes, once the court sees that it's all proper, then they basically send out that complaint to the person who's being complained about, and then it all starts. But that has to happen within a year of the issue. That is all effective as of December 15th, 2023. And that is YouTube's terms of service. So thank you guys for watching this video, and I will be going into YouTube's next terms, or I think I'll go into their privacy policy first, just because terms of service and then privacy policies seem to be the the main go-tos for each and every website. But yeah, we'll go from there. Till next time. Peace.